Welcome to week 3. This is the beginning of perhaps the core subject for business law. Very important you understand the basics of a common law contract. So we're going to talk about the 4 basic elements of a valid contract, and let me just highlight a few of those. You have to have capacity. Now capacity, think about it, you've got to have a mind to meet. If a person's insane, if they are if they don't exist, like if you have a contract with a non-existent entity, there's no capacity there. Your book talks primarily about minors and people that have mental issues and things like that. Think also about the fact that you have to have a legitimate business entity to have a contract. That's important to understand. Void and voidable contracts, the term really is self-explanatory. Void contracts are those that are like illegal. And that's one of the other elements of an enforceable contract. You got to have capacity. You got to have an agreement, which boils down to offer and acceptance, which your book talks more about, each element of that. And then it's got to be a legal deal. And lastly, you have to have this thing called consideration, which is pretty self-explanatory. And let me just highlight this briefly. Consideration is simply there's a bargain for exchange. Normally it's money. It can be forbearance. I gave up a job because you promised me a job, so I suffered. That would be enough to meet the consideration element of an enforceable contract. I already talked about capacity, but make sure you verify who you're dealing with. Always do this. This is critical. Always verify who you're dealing with. And normally a contract will identify who you're dealing with. Minors, that's an issue that normally isn't a big deal, but legality can be a problem. I mean, out of the box, if somebody wants you to enter into a contract concerning some contraband, forget about enforceability of that. But it does come up in terms of covenants, property covenants, and whether they can be enforceable. That's been a subject of some dispute. Exculpatory clause, just think of the word escape. This is like if you go on vacation and you want to have fun, and let's say you decide to paraglide or scuba dive or do something crazy, ski or whatever, and they'll have you'll sign a contract, and on it it'll say if you die, your problem. Those are called exculpatory clauses. Now, if you knowingly and voluntarily enter into that and agree to it, for the most part, they are enforceable. Unilateral, bilateral, understand what they mean. Unilateral is promise looking for performance. Bilateral is promise looking for a promise. Statute of frauds. Make sure you understand what this is. This is the idea that there are statutes that say certain contracts to be enforceable as contracts must be in writing. So, for example, real estate contracts, any interest in real property to be enforceable as a contract have to be in writing. Contracts that cannot be performed within 1 year. If I hire you on a 3-year contract orally and that's not in writing, you can't enforce it as a contract. There might be other ways to do it. And we'll talk about that. Very important concept is this assignment concept. This is an assignment of a right. For example, a right to be paid. I take out a loan, let's say your student loan or a home loan. The bank or the lender can assign the right to be paid to somebody else. Now, it's important to understand that bank is the assignor. Who they assigned it to is the assignee. The assignee steps in the shoes. Remember that term, steps in the shoes of the assignor. So if there's some goofiness in the original contract, like fraud, remember back in the prior video about torts, if there's fraud involved, the assignee inherits that problem and the debtor can raise that with the assignee. Delegation of a duty, like duty to perform. Oftentimes contracts just simply say assignment. Now, at the end of the rainbow here, a contract is discharged by hopefully full performance. Could be substantial performance, which means not everything was done correctly, but then some accommodation is made. If there is a major problem, the parties can agree to what's called an accord and satisfaction between the parties, just basically the idea that we're going to accept different performance. You should understand the term novation is where basically a party agrees that the assignee will totally substitute for the assignor, or the delegatee will totally substitute for the delegator. Damages, you've heard these before, but various types on breach of contract, compensatory to compensate you, to put you back in a position you would have been had the breach not occurred. Of course, the parties can rescind the contract, can seek restitution. And again, as we discussed in the prior video about ADR clauses, most smart business people will try to put a limitation of liability clause in their contract. This is called liquidated damages, where you set forth up front if there's a problem, if the building isn't built within a particular period of time, that there'd be a penalty so much per day. So, and this is very common in construction contracts. All right, lots of resources in this regard. I'll just highlight a few of these for you. Among them is the parole evidence rule. This is the idea that if you have a final written agreement, normally there will be a provision in the written agreement saying this is the final deal. There's no other written or oral understanding. You can't introduce other written or oral understandings that contradict the final writing. Doesn't mean you can't introduce prior written or oral understandings that explain the final product, and doesn't mean you can't introduce subsequent written or oral understanding. So this is called the parole evidence rule. Just keep that in mind. Statute of limitations, every crime except for murder, every tort has a statute of limitations. This is an important concept to understand. These are in statutes. They will say specifically, for example, a written contract in the state of Washington has a 6-year statute of limitations from the date of the breach, normally. Oral contract, 3 years. Mistakes in forming a contract, you'll see there's a great video on if it's a mutual mistake, there's no meeting of the mind, so you've got nothing. If it's a unilateral mistake, normally the contract is enforceable unless the other side knew about the mistake and kind of manipulated the situation. I've already talked about unilateral and bilateral contracts, and there's a couple videos here that will help you if you don't understand that concept. Couple highlights here: promissory estoppel and quasi-contract. These are very important terms. I treat these more or less like remedies. So, for example, with promissory estoppel, you see the word stop here, S-T-O-P, S-T-O-P. This is the idea that I'm going to stop you from reneging on your promise. You promised to pay me. I performed on a unilateral contract. You're not paying me. And let's say there's some reason why it's not enforceable as a contract. Maybe that it's not definite enough or something like that. I can sue you under this concept of promissory estoppel. This is one of the equitable, more or less an equitable remedy that the parties have if there isn't an enforceable contract. Let me just say with promissory estoppel, the big deal is detrimental reliance on the promise. Quasi-contract is a term that suggests this is sort of like a contract, but for whatever reason doesn't make it. And the key concept here is unjust enrichment. If, for example, I'm sitting at home on my porch, a crew comes up to put gutters on the neighbor's house, but mistakenly comes to my house. I see them come, they put gutters on my house. I say thank you, and they want to be paid. I go, no contract, you've got the wrong house. They could still recover based on quasi-contract because of unjust enrichment. Just a few more things I'll illustrate here. Anticipatory repudiation. This is the idea, the other side's not going to be able to perform, so you anticipate that they're going to repudiate the contract. You can go ahead and enforce it or take whatever measures you have to take to cut your losses. So keep that in mind. Contractual damages and equitable remedies. Contractual damages, money. Equitable remedies include things like injunctive relief. I'm going to enjoin you, stop you. Specific performance. I bought the land, I bought the painting. That's what I want. I don't want money. I want what I contracted for. So keep that in mind.